Hi, everyone. This is Matt with ESI Survival Guide. We are an online resource designed to help legal professionals navigate the electronic wilderness. And we have discussions with the world's leading experts about topics, trends, and developments that live at the intersection of law and technology. I'm so excited to introduce our guest today. But before I do that, if you do find the video helpful, please like, share, comment, and subscribe to the channel. That helps with the algorithm and to push the video out to more of your colleagues. And if I could give our disclaimer, the comments of myself and my guest are ours alone and are not representative of our respective organizations. And this is meant to be educational and not legal advice. So if you are facing a specific legal situation, please consult with your attorney. And with that, I'm so excited to introduce everyone to Karolina Mojzesowicz, who is the Deputy Head of Unit Data Protection for the European Commission. Karolina, how are you? How are things in Brussels?
A great beginning of the summer. It's always nice. I mean, already advanced summer, but beginning of the holiday period. So good.
Wonderful. Things are great in New York City too. Your title, you're the only person on the planet who has that title. Could you describe briefly what is it exactly that you do?
Well, I work in this governmental body, European Commission, which is divided into different directorates. I work in a directorate which is dealing with issues concerning justice and consumer protection. And within this directorate, we also deal with issues concerning data protection, GDPR, be it legislation concerning personal data and be it international outreach, which is done by different people. So I do work on questions concerning policy of processing or protection of personal data in the EU.
And one of the things we talk about a lot on the guide are cross-border developments and trends. Of course, the GDPR has been a ubiquitous topic on the podcast. And so I wanted to dive right into this very specific subject that we're talking about today. Literally days ago, the European Commission proposed some updates to the GDPR. Can you talk specifically about what exactly happened a few days ago?
Well, Matt, thank you very much for bringing it up, because it's not an update. It's not a change to the GDPR. Yeah. So here, very big no update. It's we the Commission, we proposed rules regulating, harmonizing procedures which the data protection authorities apply when they enforce the GDPR in cross-border cases. So in cases when there is a complaint in one member state, in, for example, Germany, but the authority who will deal with the case is established in another member state, let's say France. So an individual in Germany complains about something that is being done, this processing of personal data is being done by a controller processor entity which is established in France. And here we are providing for the rules for cooperation in such cases.
So more of a complement than an update.
Yes, very much.
Wonderful.
So.
Thanks for that clarification. But Karolina, one question I have is, didn't we already have this harmonization? I mean, didn't the one-stop shop under GDPR, and for those of you that may not be familiar, essentially the one-stop shop was a mechanism by which organizations that were dealing with processing data cross-border could deal with one supervisory authority, probably the one that was in their headquartered member nation or where they were doing most of their processing activity. But didn't the one-stop shop already handle this type of issue? And how do these complements, if you will, address the one-stop shop?
Well, the GDPR, as you just said, Matthew, established this cooperation procedure, one-stop shop, and the consistency procedure, of which dispute resolution is a part. But it regulated really what should be achieved, but not so much how. So the procedure. And our member states, while applying the GDPR, do it with the tools of their administrative procedural rules, which are still diverging. There is a different way of enforcing the GDPR in one member state and in another. This how is regulated by national administrative procedural laws. And in order to ensure quicker, better cooperation, we decided now to harmonize in a very surgical way some of these national procedural rules.
I like that, surgical harmonization. It sounds like a cool band name.
Member states are very jealous about their what we call procedural autonomy. So when they agree to harmonize something on that, they tell us, well, do what is only strictly necessary in order to achieve something. Do not go beyond. And there we focused on cooperation of enforcement of cross-border cases, and also on very few, if you want, elements which were necessary in order to make this enforcement more efficient.
Is there still a long way to go to actually achieve that harmonization, or do these new procedural rules have that harmonization baked in? Is there already a mechanism and steps to actually facilitate that harmony?
Well, this is a regulation. It means it's directly applicable in the member states. So it will, when it will be adopted, a law. But what we did is we proposed it now, and the two European legislators, the Council and the European Parliament, will have to agree on it. And we hope it will happen very quickly.
Understood. Now everybody watching is probably thinking, okay, how does this affect me? If we could go through the main categories of stakeholders that this is likely to affect, the first being data protection authorities. How does this change the role of the DPA?
This does not change the role of the DPA. It just provides, it streamlines the way they cooperate in the cases. How the one-stop shop works now. You have one authority, which the lead authority, when there is the main establishment, which or opens the case on its own volition, or receives from another authority, from another member state, a complaint which concerns activities of a controller processor established on the territory for which this authority is competent. In such cases, this lead authority investigates with the support and involvement of other authorities, concerned authorities, to which belong the authority which received the complaint and the authority of all the other member states who have the data subject which are affected or are likely to be affected by the processing operations in question. So, by big undertakings, this is sometimes the whole EU. In some cases, these are several member states, sometimes only 2 or 3. It depends.
Do these new procedural rules or proposed rules, do they change the way that a complainant brings a complaint or how they interact with GDPR? How does this change the actions of an actual individual complainant?
Well, complaint is already regulated in the GDPR. It's Article 77. Every data subject resident in the EU has a right to lodge a complaint. What we do is to harmonize, if you want, the conditions of this complaint. We say what authorities can ask when they assess if such a complaint is admissible or not. We want to cut off on the discussions whether additional information or points would be necessary before then lead accepts this complaint as a valid complaint. So this is the first thing we do. Indeed, it's the first pillar of this proposal. Harmonization of the conditions of what is a complaint in cross-border cases.
And what about businesses? So if I run a business and I have operations in multiple member nations and I'm doing significant cross-border data transfers and processing across member nation lines, how does this impact me?
Well, it does not affect, as we said already before, any of your obligations or any of the rights. What it does It just provides or streamlines the due process rights you will have when an authority in a cross-border case investigates against you. Yeah, when an authority, the lead authority, engages with you, we provided for a step when the right to be heard is to be exercised. We clarified what does it mean, an administrative file and access to such a file. And we provided for additional possibility to be heard by the board should there be a need for a dispute resolution.
So whenever there's some change or some development in the EU, I know from my colleagues in the States, everybody always gets up in arms about, okay, more compliance obligations. But it sounds here like this really is an exercise in clarification, and that it's actually going to help make things easier, give folks more certainty and ability to plan and kind of understand what the impact could be of their processing activities. Would you agree with that?
I would say that it just affects you when you have an investigation against you. When an authority engages with you and says, well, I open a case, and then it clarifies on the basis of what and when you will be heard, and access to what and when you will have in order to be able to effectively defend yourself against the possible allegations of the authority investigating you.
That's wonderful. And Karolina, I can't thank you enough for this clarification. I know for a fact this is going to be eye-opening and very helpful to a lot of people, whether they're an armchair GDPR enthusiast or they actually have significant compliance obligations in the EU under GDPR. If I wanted to follow the developments with these proposed procedural rules, how would I do that? Would I follow them on the European Commission's website, or is there some other resource that I would use?
I would think so. I think we will be updating our page, but it's also at the page of the Council and the European Parliament, which will be then engaging now with our proposal. But if you allow me, there is another very important element in our proposal, namely the position of the complainant. Our member states have a very different ways of engaging with the complainant when, in particular, they follow up on the complaint. So when a DPA, Data Protection Authority, receives a complaint, we had in some member states a system which provides only for the information to this complainant. I open a case, I investigate upon your complaint, and it's done. And then one day, this complainant receives the decision the authority adopted against the controller processor. In some other member states, we had a very strong involvement of the data of the complainant, where it was really treated as an integral part to the party to the whole investigation. And we, between these two approaches, we chose a middle one where we provide for an involvement of a complainant in a case when an authority follows up on a complaint. But on the other hand, we still distinguish this situation from that of the parties under investigation. We underline that it's an authority which investigates the case and which can get all this information from the complainant, needs to inform the complainant about the development of the case. This development of the case, this is already provided for in the GDPR, but the authority needs to investigate in full independence of any kind of influence.
How do you anticipate that working practically when you have a very, very large investigation? So I imagine that if you have a relatively small investigation where the complainant or complainants is a small group, what if you have one where there's thousands or tens of thousands of folks? Would that resemble almost like a class type structure where the involvement of the complainant is done through a representative, or would every individual have some type of involvement?
Well, what we provide for is that in a situation where there is an authority investigates, follows up on the complaint, that the complainant will be given access to the non-confidential version of a document on the basis of which parties under investigation will be exercising their due process rights. Yeah, we call it preliminary findings, and parties under investigation will be replying in writing to it, and a complainant will be able to submit comments on the non-confidential version of such a document. How the complainant will want to be represented, and if there is a group, an association, we do not enter into that. It can be that in one case there will be several complainants from several different member states. What for us mattered is that they will all be included in a specific defined step in the procedure, and they will be included in the same way throughout the EU.
Well, this is a fantastic development. I really do think this is going to create a significant benefit to folks that are being investigated, and also bring some clarity to the investigative process. So kudos on that. What is the next step in terms of going from proposed rules to this being kind of black letter law, if you will, in the EU? What's that look like? Is that going to be another 6 months, a year, 2 years? What's that procedure look like?
Well, as I mentioned, this proposal, which was adopted by the Commission, is transmitted now to the Council, to the European Parliament, and they will start their work on this document. They will prepare their versions, and then we will enter into so-called trilogues, where there will be a Council, the European Parliament, and the Commission working on the final version of the law.
We'll definitely keep you all informed of any updates that happen. And Karolina, are there any, I know what my final comment would be, and it would be, again, clarifying my first initial comment about this being an update versus a complementary measure. But do you have any final comment for our listeners on these proposed procedural rules?
Well, have a look. They're very interesting, I think. But indeed, they affect businesses to which GDPR applies directly in the EU.
Karolina, thank you so much for joining us today. I know I learned a lot. And if you out there, if you found the video helpful, again, please like, share, comment, and subscribe. It definitely helps. And also stay tuned. Karolina has so graciously agreed to join us on a future episode and talk about the EU's Artificial Intelligence Act insofar as it impacts the processing of personal data. So we're going to focus specifically on that issue, which I know is a hot topic for a lot of folks. And with that, this is Matt signing off with ESI Survival Guide. Please stay safe out there in the electronic wilderness. See you next time. Bye.